Good morning once again, my esteemed young barristers to be. Today, in continuation of our lecture series on public international law, we shall be looking at states and recognition in international law. Recall that we say states are key in international law, and they have what we call legal personality. Today we shall look at the recognition of states in international law, because the legal personality of a state is an important factor in determining the rights and obligations in international relations. In these lectures, we will examine the meaning of statehood and the criteria for states, as well as the role of recognition in international legal system. Now, what is the meaning of statehood? Statehood is a legal concept that refers to the status of an entity as a sovereign state in international law. A sovereign state is an entity that has supreme authority over its territory and population and is recognized as such by other states. The concept of statehood is based on the principles of territorial integrity, political independence, and self-determination. Now let us look at the criteria for statehood. Before an entity is considered state, it must possess some of these some of these factors. These are a defined territory. A state must have what? A defined territory. Nigeria has a defined territory. Ghana, United States, Uganda, they all have defined territory. So a state must enjoy a defined territory that is called its own. That's a geographical entity that belongs to it before we recognize it under international law. Now it must also have a permanent population. This presupposes that a state must have a population and which is permanent and stable, and that it is the subject and that is subject to the authority of the state. That's the population must be subject to the authority of the state. It must also have a government. A state under international law must have a government. In Nigeria, Ghana, Uganda, they all have government. So we can only deal with you under international law when you have a government. What is the role of government? The government controls the population, controls your acts, your rights and obligations. Now also finally, the capacity of the state to enter into international relations. Once a state has the ability, the capacity to enter into an international relations with other countries, we say it has what? Statehood. Now, having said that, we have, why is this recognition important? We look at the role of recognition under international law. Recognition is the process by which one state acknowledges the existence of another state. For instance, Ghana acknowledging the existence of Nigeria, and it accepts its legal personality, where each state recognizes a particular state as being a country and then that has legal personality. So recognition is important. It's an important factor in determining the legal status of a state in international law. Recognition, as we've said, again, let me repeat it, is an important factor in determining the legal status of a state under international law. A state must have that recognition by other states before we allow it to come within the international law fold. Now, recognition can be either, there are two types of recognition. The first one is called de facto recognition, and then the second one is de jure recognition. Understandably, they are not English words, they are Latin words, but you have to take them as they are. What is de facto recognition? This refers to the situation where a state is recognized by other states based on its effective control over its territory and population. regardless of whether it meets all the criteria for statehood. I take that again. De facto recognition refers to the situation where a state is recognized by other states, mind you, by not all states, by other states, based on its effective control over its territory and population, regardless of whether it meets all the criteria. Now, two things will come to your mind. Not every country recognizes itself, and then the same de facto recognition presupposes that certain criteria for statehood are missing in de jure recognition. That notwithstanding, other states are ready to accept it as a state. Now, the second one is what we call de jure recognition. Now, this refers to the situation where a state is recognized by other states based on compliance with the criteria for statehood. Now, de jure recognition is based on the fact that a country is recognized as a state because it has complied, it has all the criteria, the 5 criteria we have mentioned of statehood, which will include defined territory, population, government, and ability to enter into international relations with others. We now say a state has de jure recognition. These recognitions are very, very important. Now, for further discussion or further reading in respect of statehood and recognition under international law, I have uploaded certain books for your reference, which you can Google and then read for further elucidation of the topic. We have Recognition and the United Nations by Thomas D. Grant. We have Statehood and the Law of Self-Determination by Dapo Akonde. We have the Recognition of States, Law and Practice in Debate and Evolution by Milanovic. And then we have the Law of Recognition by Hash Lutapog. Now, finally, the concept of state in international law. Now, of course, we have certain statutes that go to support the preposition we have mentioned on statehood. They include these are statutes: the Montevideo Convention on the Rights and Duties of States, entered in, it's an old statute in 1933 statutes. The Vienna Convention on Diplomatic Relations, entered in 1961. The Vienna Convention on Consular Relations, 1963. The United Nations Charter, 1945. As I've said, UN Charter in public international law is a must read. You must acquaint yourself with the provisions of the United Nations Charter. You discover that every item of reference on status that have been given have been mentioned in the United Nations Charter. Then the last but not the least is the Convention on the Prevention and Punishment of the Crime of Genocide. Now, we have also certain cases that support the preposition of statehood. Southwest Africa, that's Ethiopia, that's in South Africa. We have Ethiopia versus South Africa, Liberia versus South Africa, all in 1962. We have the Western Sahara, that's an advisory opinion given by the International Court of Justice in 1975. Now, we have also the application of the Convention on the Punishment of the Crime of Genocide. We are referring to the case of Bosnia and Herzegovina versus Serbia and Montenegro. They are all cases delivered in 2007. We have also the Barcelona traction case, which I have earlier referred to, between Belgium and Spain. It's a 1970 case. And then the case of Kosovo's declaration of independence, which was an advisory opinion given by the International Court of Justice in 2010. Now, having said that, in addition to these cases that are the books, statutes, and cases that I have made reference to here for you to read up, I have also included some YouTube links for you, which are also there for you to read up on lectures given by eminent scholars on legal, on statehood recognition, just like the one I am giving. So I have given 2 YouTube links for you to check up, listen to them, then juxtapose them with what I have done, with what I'm doing right now to you, so that you will have an all-embracing idea of what the role of recognition and of statehood encompasses. Thank you very much and have a great day.